This is Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to the Bloomberg Law Show. I'm June Grasso. TikTok may disappear in the U.S. next month after an appellate court upholds a ban. Transgender rights at a legal crossroad as the Supreme Court's conservatives seem ready to uphold a Tennessee ban on gender-affirming treatments for minors. And the rap battle between superstar rappers Drake and Kendrick Lamar ends up in court, sort of.
For all of those that want to save TikTok in America, vote for Trump. The other side's closing it up. But I'm now a big star on TikTok.
President-elect Donald Trump campaigned on saving TikTok as he courted younger Americans, despite trying to force its sale during his first term. But on Friday, the D.C. Circuit Court of Appeals unanimously upheld the new U.S. law which bans TikTok unless it divests from Chinese ownership, ruling that the ban doesn't violate free speech rights. The ban will kick in on January 19th, the day before Trump is inaugurated. And in any event, it's unclear what Trump could do at this point. The only hope for TikTok and its more than 170 million American users appears to be the Supreme Court, and the company says it will appeal the decision to the court. Joining me is Eric Goldman, a professor at Santa Clara University Law School and co-director of the High Tech Law Institute. So, Eric, this three-judge panel unanimously upheld the law banning TikTok. How did they reach that conclusion?
The majority's view is that the TikTok ban satisfied the highest levels of constitutional scrutiny, that even if it was conceived as a restriction on speech, that the government's national security interests were compelling enough to justify the speech restrictive effects.
Did they acknowledge the First Amendment interests at stake here?
Yes, they did. And the majority, in fact, applied the highest level of protection that's available for free speech and still said that this was a justifiable intervention. And that's a rare outcome when a court says that a law survives that highest level of scrutiny. And usually it's a sign that the court is either not actually taking that test seriously or that they are bending the factors in a way that lead to a very unexpected outcome.
The U.S. government didn't offer evidence that China had used the app to influence U.S. citizens or steal data. But yet the court wrote, here the government acted solely to protect that freedom from a foreign adversary nation and to limit the adversary's ability to gather data on people in the United States. But there was no evidence of that.
The court essentially was willing to accept the government's hypothetical concerns that there could be some adverse outcome to U.S. democracy should China in the future at some point choose to take advantage of whatever leverage it has to manipulate the content on TikTok. Normally, that kind of hypothetical concern is too abstract to be recognized by a court. There's a lot of things that could happen in the future. We can't use all of those possibilities to justify something as serious as an incursion on our free speech rights. So the fact that the court was willing to entertain that hypothetical is part of how they reached a really surprising outcome that this law survived the highest levels of scrutiny. They should not have given as much weight to that potential hypothetical that had not yet happened.
A part of the government's information was redacted and hidden from the public as well as the companies, TikTok and ByteDance, so they had to fight the ban without all the information.
So there has been a lot of discussion about confidential or sensitive information regarding TikTok's behavior that has not seen the light of public day. This court chose to ignore that data, and it claimed that it was ruling solely based on publicly available information. They were saying that what's available in the public was enough to justify the government's intervention.
And this panel consisted of the chief judge, who's a Barack Obama appointee, a Trump appointee, and a Ronald Reagan appointee. So it cut across political lines.
That's correct. I don't look at this opinion as a partisan opinion. And ideally, of course, the opinions are never partisan, but we sometimes question that. And of course, the efforts to ban TikTok have been bipartisan. They've come from both a Republican president, a Democratic president, and got bipartisan support in Congress. So I don't really think that the partisan angle really helps here. I do think that the xenophobia, the ongoing relentless criticism of the Chinese government really carry the day in a lot of respects for all sides.
So the ban kicks in the day before President-elect Donald Trump is inaugurated. His Justice Department would have to enforce it. And even though he tried to ban TikTok during his first term, he said during the most recent presidential campaign that he's now against a TikTok ban and would work to save the social media platform. Where does that all fit in?
I don't know what President Trump is going to do again. His statements are wildly inconsistent with each other. The last official act he has taken on this topic, he attempted to ban TikTok. So he might have had a change of heart, but we will only know based on his actions. I think the bigger question is, will the Supreme Court have a chance to weigh in before the deadline that was set in the statute, which seems highly unlikely. And it would be, I think, logical for President Biden to extend the ban implementation until the Supreme Court has had a chance to weigh in. And of course, if President Biden does that, then that would kick the issue over to President Trump for whatever chaos might ensue.
Yeah, so President Biden can grant a 90-day extension if there's progress toward divestiture. So let's say that Biden does grant the extension and the Supreme Court does hear the case on an emergency basis. How likely are they to block the law, at least temporarily?
One of the options available to the Supreme Court will be to delay the effectiveness of the act until it completes its review. And I don't know if they're going to choose to do that or not. They might view that as solely an executive function where the government doesn't have to pursue implementation until the Supreme Court has weighed in. So the Supreme Court's responses to emergency requests like that have been somewhat chaotic. And so I'm not sure what they would do this time.
If the merits question gets to them, do you have any feel for how they would view it?
So I do. The TikTok ban really cuts across traditional lines. It pulls together a coalition of adherents or supporters who might otherwise not come together, whether that's because of the fears of China or the concerns about national security or the lack of interest in free speech. The coalitions just look different when it comes to a TikTok ban than maybe other kinds of government restrictions. But in July, the Supreme Court was quite clear that if we are concerned about bias on social media, the government does not have the right to intervene to de-bias or unbias social media. It was very explicit in the opinion that the solution to concerns about editorial discretion on social media is not government censorship. And the D.C. Circuit's opinion seemed to disregard that. They didn't really acknowledge that very expressed concern that was on the minds of the Supreme Court. So if the Supreme Court continues that logic, I think there's good reason to question whether or not the TikTok ban can survive, because the government is in fact trying to de-bias the social media through government intervention. But we don't know if the Supreme Court really meant what it said, or if they will see this as a qualitatively different circumstance for pick your favorite reason. So it's really hard to predict where the Supreme Court might come out, and it's even more troubling if they try to do a rush job. Because when they do a rush job, then don't have the time and flexibility to really try to even get in sync with each other and coordinate their statements of justifications.
So what actually happens on January 19th, on the deadline for TikTok?
So the main thing is that on that date, we would assume that the app stores will take TikTok out of their offerings. The app stores are really a key player in this conversation, and they're essentially invisible in the court's opinion and in public discussion. The app stores didn't weigh in, for example, on the bans. They're just sitting silently, waiting for people to tell them what to do. So if the government tells the app stores to kick TikTok out of its app stores, that's going to be the first step in the shrinking of TikTok's user base. There may be ways to get TikTok installed otherwise, and I'm sure some people will try. But over time, if it's really hard to install an app, that app starts to wither away. Whether or not there will be any further disruptions to the enjoyment of TikTok by people who have it already installed is unclear to me. We'll have to see. But if an app isn't growing like TikTok, its future is already sealed or faded. Of course, there's a possibility that TikTok will try to find some kind of last-ditch sale. And that, of course, would solve the problem, but it's something that TikTok has repeatedly insisted they cannot do. So we're like living in terra nova that way. We don't really know what the world looks like when a government like ours decides to just ban an app.
An app that 170 million Americans use.
And many of them are incredibly passionate about their use. And when I talk to my students about this at the beginning of the semester in internet law, they were shocked about the fact that Congress had banned the app. They can't imagine that Congress would do something that was so contrary to their interests. And I think many of those 170 million users are in for a very big surprise very soon if the Supreme Court doesn't reach a different conclusion.
Theoretically, suppose the Trump administration decides it's not going to enforce it. It's not going to tell the apps to remove TikTok. I mean, is that possible?
It's possible, but it's unclear that that solves any problem. If the U.S. government were to issue a statement to the app stores that they're free to continue carrying TikTok without fear of government prosecution, you could imagine app stores feeling like that's a sufficiently credible statement to rely upon it. But if it comes from the Trump administration, which is notorious for flip-flopping on policy matters, I can't see how that would give any app store any confidence. If it were my decision, knowing that there's severe sanctions for violation, knowing that that gives leverage to a mercurial government, I wouldn't play by those rules.
Does it seem like Meta and Google have the most to gain from a TikTok ban?
Well, we know that Facebook ran its own, quote, influence operation, tainting TikTok for many years. They spent millions of dollars trying to portray TikTok as an evil actor in Washington, D.C. And so in that respect, not only do they seem to see some financial benefit to knocking TikTok out of the market, but it seems like that's working so far. So, we could certainly see why Facebook might view this as a net win for it. From my perspective, if the government can choose winners and losers in the speech marketplace, there's no reason to believe Facebook is going to avoid that. So they're playing with fire. But Facebook has chosen to play with fire, and so far it seems to be working for them.
Well, it seemed to work on Friday, the day of the court's decision. Meta shares surged as much as 3.4% to an intraday record. Google was up as much as 1.4%. Thanks so much for your insights, Eric. That's Professor Eric Goldman of Santa Clara University Law School. Coming up next on the Bloomberg Law Show, it's the most high-profile case of the Supreme Court term so far, and the court's conservative justices seem ready to uphold a Tennessee law banning gender-affirming treatments for minors. We'll talk to counsel for the transgender teenagers and their parents who are challenging the law. I'm June Grasso, and you're listening to Bloomberg.
Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs.
It was a historic day at the Supreme Court on Wednesday as ACLU lawyer Chase Strangio became the first transgender attorney ever to argue a case at the court. 3 transgender teenagers and their families are challenging a Tennessee law that bans doctors from prescribing puberty blockers and hormone treatments to minors with gender dysphoria, arguing that the law unconstitutionally discriminates against transgender people based on their sex. The court's 3 liberal justices, like Elena Kagan, were pointed in their criticism of the law and Tennessee's argument that the law's bans are based on medical purposes and not sex.
It's a dodge to say that this is not based on sex, it's based on medical purpose, when the medical purpose is utterly and entirely about sex.
However, the conservative justices like Chief Justice John Roberts and Justice Brett Kavanaugh expressed reluctance to get into the middle of the medical and policy debate and second-guess the judgments of state lawmakers.
We might think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor.
If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Liberal Justice Sonia Sotomayor had the answer, noting that transgender people make up less than 1% of the U.S. population.
When you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
you blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
An indication of how the arguments were going? Liberal Justice Ketanji Brown Jackson said she was worried that the court would undermine bedrock principles of equal protection analysis and the legal basis of landmark constitutional rulings like Loving versus Virginia, which struck down Virginia's ban on interracial marriage in 1967.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made.
Joining me is the counsel for the transgender teenagers and their families in this case, David Cole, a professor at Georgetown Law who was until recently the National Legal Director for the American Civil Liberties Union. David, I know you were in the courtroom with the teenagers and their families for the oral arguments. What's your general impression of the arguments?
Well, it was a spirited argument. It was an argument in which I think a number of the conservative justices expressed concern about how they are supposed to review a judgment that involves medical, scientific evidence and uncertainty, but also where, there was really no good response to the contention, our contention, that the law discriminates on the basis of sex. It allows medical treatment if it is consistent with the sex that one is assigned at birth. It bars the treatment if it is inconsistent with your sex assigned at birth. When you tell someone that you can do something only if it's consistent with your sex, that is a sex-based classification. If you told people you can only pursue careers that are consistent with your sex, everyone would recognize that that's a sex-based classification. So while some of the conservative members are concerned about the medical issues that underlie this case, the question in the case was simply, what is the proper standard of review, and is this actually sex discrimination?
It seemed to me like the liberal justices discussed that, but the conservatives stayed away from that issue. The Tennessee Attorney General argued that the law restricts the use of drugs based on medical purpose, not based on sex.
Yeah, that's what he says. But if you read the law on its face, you can get medical treatment if it is consistent with your sex assigned at birth. You can't get the same treatment if it allows you to live or identify inconsistent with your sex assigned at birth. And that is a sex classification. It is enforcing particular, sexual stereotypes on people. If you have a birth sex of male, you can get treatment if you want to masculinize, but you can't get treatment if you want to feminize. And the opposite rule applies to birth sex females. That's treating boys and girls differently by seeking to enforce gender conformity.
Some of the conservative justices, particularly the Chief Justice and Justice Kavanaugh, said that, we're judges, we're not doctors, let's leave it up to the lawmakers. They don't always leave it up to the lawmakers.
Right. You leave certain things up to the lawmakers, but you don't leave equal protection of the law up to the lawmakers. You don't leave constitutional rights up to the lawmakers. And those same conservative justices were quite willing and ready to review COVID regulations, which were imposed for public health reasons at a time when people were dying by the, tens of thousands, and to strike down those regulations that they felt interfered with religious free exercise rights. The same thing is true here. Yes, it's in the area of medical regulation. Yes, that's something that judges don't ordinarily do. But when you discriminate on the basis of sex, as this statute does on its face, the court's obligation is to make sure that the state has demonstrated that this ban, a categorical ban, is necessary to further the interest that they assert. That's what the Constitution demands, and there's no exception for medical treatment that says you can discriminate on the basis of sex when you're engaged in medical treatment.
Toward the end of the oral arguments, Justice Ketanji Brown Jackson said she was worried and nervous. I've never heard a justice say anything like that in an oral argument before.
Yeah. Well, I think she was reacting to many of her conservative colleagues who seem to not want to engage with the principal question in the case, whether it's sex discrimination, and instead wanted to engage on whether there's medical uncertainty and what the evidence shows, questions that are really not before them, and with the suggestion that if it's a hard question and if there's medical uncertainty, we ought to accept a law that discriminates on its face as sex-based and accept it as somehow sex-neutral. And, she was concerned because those kinds of arguments were made by the state of Virginia in Loving versus Virginia in defending a law that prohibited interracial marriage. The state said, and she quoted it in court, that there's scientific evidence that supports prohibiting people from marrying across races, and this is not a race classification because it applies to whites and blacks equally. The court rejected that and said, no, when it determines what you can do based on your race, that's a race classification. Same thing here. When the law determines what you can do based on your sex and whether you are acting in a way that the state of Tennessee thinks is consistent with how it thinks people of your sex should act, that's a sex classification.
I found it odd that Justice Neil Gorsuch, who wrote the Supreme Court's landmark decision that protected LGBTQ people from discrimination in the workplace, was silent during 2.5 hours of arguments, didn't ask one question.
Yeah. No, that was odd. And I argued the Bostock case in which, on behalf of Amy Stevens, the transgender woman who was fired from a funeral home when she came out as transgender. And he was very active in that case. I read that as he may be uncertain about where he is in this case. And so he wanted to sit back and listen and hear what other people said rather than speak up, especially because he wrote the Bostock decision. But, the Bostock decision said that when you discriminate against someone because they are transgender, that is, by definition, as a matter of logic, discriminating against them because of their sex, treating them differently because of their sex. If that's the case, then certainly a law that on its face says you can get treatment if you do it consistent with your sex and you can't get treatment if you do it inconsistent with your sex should also be subject to heightened scrutiny as sex discrimination. So we'll see how he votes, but he gave no indication.
So there seems to be a consensus among the legal pundits and Supreme Court reporters that there are 5 votes to uphold Tennessee's ban. Do you agree with that?
I think the 5 conservatives who spoke all expressed some unease with recognizing that this is sex discrimination. It may be that when they go back into their conference and they study the matter further, they may decide, a law that on its face defines what can be done and what can't be done based on whether it's consistent with sex or inconsistent with sex is sex-based, and it would be ludicrous to suggest it's not. It may be that the law could satisfy heightened scrutiny on remand, and they could say, that heightened scrutiny should apply with a softer touch when you're dealing with issues of medical uncertainty. So I don't think it's absolutely clear that our side lost, but certainly 5 justices expressed some discomfort with ruling in our favor.
This is a fraught time for transgender Americans. Donald Trump campaigned on a pledge to roll back transgender rights. If the justices affirm the Tennessee ban, what does that mean for transgender rights in this country?
You're absolutely right that this is a time where one side of the aisle is targeting trans people for political exploitation. For the court to sort of allow that to happen and to say that a law of this type that is facially sex-based is somehow sex-neutral and can be upheld without any searching inquiry into whether the state has a legitimate interest and whether it is furthering it in a tailored way would just open the door to rampant anti-trans discrimination across the country. And as was pointed out at argument, if it's okay for Tennessee to do this, then it would be okay for the entire country, for Congress to do this, to deny to every trans youth and every parent of every trans youth who has determined that this treatment is medically necessary with their doctors, to deny them the ability to get it anywhere in this country. There would be no bar to such a draconian policy. So I think that would be a terrible, terrible result for trans people.
How did your clients, particularly the 3 transgender teenagers, how did they feel after these arguments?
Well, I think they look to us, but they also can hear the concerns. And I think, some of the concerns that were articulated were pretty hostile to who they are, to the plight that they face, to the really, really difficult decisions that, parents and families have to make in these situations. And to hear, the justices say, well, it's too complicated, it's too difficult for us to address, even where a statute on its face discriminates on the basis of sex. Very disappointing, very disappointing.
It must be such a difficult position for teenagers to be in. I really appreciate your coming on the show, David. That's Professor David Cole of Georgetown Law. Coming up next on the Bloomberg Law Show, a rap battle in court. Sort of. I'm June Grasso, and you're listening to Bloomberg.
Psst. I see dead people.
That's hip-hop superstar Kendrick Lamar's wildly popular track, Not Like Us. Lamar's track disses another hip-hop superstar, Drake.
Say, Drake, I hear you like I'm young. You better not ever go to Cell Block 1.
But Drake has taken their bitter rap feud to a new level. And it may be the first time someone in a rap battle ran to a court for help. Drake has filed legal actions in New York and Texas against Universal Music Group, the parent company of the labels for both artists. The theory is that Universal artificially promoted the song of one of its artists, Kendrick Lamar, that damaged the reputation and earning potential of Drake, another of its artists. It seems to be a rather unique approach in the music industry. Joining me is entertainment attorney Ron Bienstock, a partner at Scorinci Hollenbeck. Ron, these aren't lawsuits yet. Tell us about the first filed in New York, which is a civil RICO pre-action suit.
Yeah, so we've got actually parallel pre-complaint filings known as petitions, one in New York, one in Texas. The pre-complaint, if you will, in New York is based upon the relationship between Universal and Spotify. Spotify is the number one streaming service in the world, where Universal is one of the 3 major giant music business powerhouses, both with records, publishing interests, and have both artists, Kendrick Lamar and Drake, through 2 different divisions assigned to Universal Music Group, which makes it even more confusing. But the petitions are looking for depositions and information to establish a full complaint cause of action against these defendants for, in New York specifically, payola, which is a 1934 law. I once said payola to some people under 30. They thought I was making that word up. Payola is the illegal payment to a radio station, or it could be any other, now in the digital age, another platform, to play a specific artist or specific piece of music. So in New York, it involves Spotify. In Texas, it involves iHeartRadio. There's some fascinating facts about this New York petition. Music, or Universal Music, owns 3.27% of Spotify. That would have been something we wouldn't have seen in the past, but the majors all have an interest now in Spotify. And that Spotify pays annually in terms of streaming and other download income, but mostly streaming income, over $2.5 billion to your music. So this is a huge relationship. When you switch to the Texas action, that really involves iHeartRadio, the number one radio station in the country. And there's been, as the pre-complaint says, a symbiotic relationship between UMusic and iHeartRadio. UMusic controls a vast number of hits over the last decade. And so if you want to have access to those hits, you're going to be close to the company that supplies that content to you.
So break it down for us. What does the first petition in New York claim?
So the first petition in New York says effectively, hey, you favored Kendrick Lamar in this now sort of infamous rap beef, as we would call this relatively new phenomena, if you will, not this East Coast, West Coast thing, but this very specific rapper versus rapper beef, which are both on the same label. The New York petition says you favored Kendrick Lamar. You boosted his song versus mine in this dispute we were having, this musical dispute we were having. and you favored him on it, and you paid someone in terms of Spotify to stream more of it, and you took advantage of what you could take advantage of to give this artist favor over me.
So what's the point of a pre-action suit? What are they looking for?
They're looking for discovery. It's kind of like saying information and belief. They're saying, hey, we think we've got some proof, but we don't have the exact verbiage we need. We need some facts. So to prove our facts so we can go and file a formal complaint with a litany of issues here, we want to have pre-complaint discovery, kind of like an expedited discovery, both in New York involving Spotify and UMusic, and then in Texas, a very similar theory where we're saying there was payola committed again with the iHeartRadio station, the national chain station. We want to have expedited discovery so we can go find out the facts. We want to talk to people from UMusic. We want to talk to people from iHeartRadio to get the facts so we can have a more formal complaint filed.
So just focusing on New York for a moment, do you think that they'll be able to get that?
It's a tough hurdle to get over here, saying we don't have enough, but we want you as the court system to provide us the right to go and do this. I don't know if they've established enough initially with this pre-complaint petition. It'll be really up to the court to allow some limited scope of discovery. Maybe they'll do that. I don't think this is going to be some wide open fields, get to talk to anyone you want. I think they're going to be very narrow to grasp some of those facts to see if they can get to the complaint stage. Remember, we're in state court. We're not in federal court. So a lot of the dismissal issues and the standards for dismissal are slightly different in New York and in Texas.
Now, is the Texas action about defamation?
It's a combination. It is, again, a payola claim saying you favored Kendrick Lamar versus me, Drake. You favored this artist, and you took advantage of your relationship and the power you wield as a powerhouse major record company and content owner. And you took advantage of that, and you preferred getting this guy boosted versus me, and you did it through iHeartRadio. Then there's this defamatory language, which kind of runs through both of the petitions, but more specifically in Texas, says you knew what he was saying could be false or was false, and you allowed him to put that into lyrics. This all took place this year, and you allowed him to put this into lyrics, and you let that into the marketplace. There's a side moment, and I wanted to bring this one issue up. I don't have Kendrick Lamar's recording agreement because that's going to be confidential, but generally with record labels, the artist has a warranty and representation that they won't defame, that they won't infringe on someone else's copyright and things of this nature. And if they do, they will have to indemnify the record company. Now, I haven't seen anybody bring this up yet because maybe we just don't know, and this is purely speculative, because Drake has not sued Kendrick Lamar personally in either of these pre-complaint petitions. But if he's looking to get some fiscal comeuppance, this may be the way, because if Kendrick Lamar is accused of defamatory lyrics, then he may have to defend by indemnifying UMusic against any of these future lawsuits.
Why is he not suing or bringing these petitions against Kendrick Lamar?
Question of the day. Is it because, if we're going to speculate, well, it's defamatory. So we're saying, hey, you claim these things are defamatory, but truth is the absolute defense. So if Kendrick Lamar has proof or knows these things to be true and can show that, that's not going to carry the day. That's not a good idea for Drake. So I think that there's a lot of personal issues going back and forth, but they're in the guise of a business petition lawsuit where we are looking to make ourselves get even with somebody in a clear battle of entertainment stalwarts, kingpins, if you will, where one did not get the success the other did. Perhaps there was this, you played unfair as UMusic. The winner here is Universal Music, unless they, of course, are going to eventually have to pay out, and if there's a decision against them, but they win both ways. You know what's going to happen. All of these songs are going to get boosted by these lawsuits. People go right back and start listening again. And there's all kinds of other issues that took place. Drake sold a portion of his catalog this year. There was a $150 million buyout in October. All of this is taking place now. And there's also this prior lawsuit of copyright infringement involving Drake and the producer Chris Brown. So Drake has some real experience here in the courtroom in this last year. Lots of filings, lots of accusations, a lot of things going on. It's a lot to keep track of.
There's been some speculation that Drake is using this to get information from Universal to somehow get out of his deal.
Mm-hmm. Yeah, that seems one of the most likely outcomes of this. We all know getting out of record deals. Now, again, I'm not privy to know the structure of his agreement. People have called it a license deal in the press. That's a different relationship. That means he owns his masters and he's licensed them. But if you have a long-term license deal and you want to pull back the ownership of those masters that you're releasing, this could be one way of doing that. Clearly, he doesn't want to do business with these people anymore. And I would say most likely Universal Music doesn't want to do business with him. So maybe that is the outcome of releases where he can get the return or reversion of all of his masters. That could be part of the game here. I don't want to use the word game because it's serious civil litigation, but that could be part of what he's looking for.
A lot of artists are problematic. Do you think that Universal really doesn't want to deal with Drake anymore, considering his success?
It's a great question. Why would you give into this and drop it? But no judge is going to keep two people together who don't get along anymore. Eventually, there's going to be a decision about the ownership of these masters and the reversion. I think that's not in these two suits, but we know that's coming. So if you're not getting along, and if they're just the distributor and promo arm, and you don't feel they're doing the job, yeah, you want out. Does that mean he'll get all of the masters back? We don't know. Does that mean he'll get prior masters up until this day or the day of the decision, stay with Universal for a period of time? That remains to be seen. But it could be that this is a methodology for Drake to get himself out of his deal with Universal.
I have to say, this is very confusing. So tell me what I missed.
There is so much stuff going on. Welcome to the modern digital age involving payola and bots and other terminology we didn't talk about with CDs and vinyl. It's a different world. And this is the 2024 version of what the 1934 payola was, when record companies in the 30s and 40s put a $100 bill inside the jacket of the vinyl album cover and gave it to someone at a radio station and wink, wink, nod, nod, please play this. This is your new favorite song. Now it's all done digitally, and now we have all AI, and we have algorithmic ways of doing this, and someone's going to have to prove that.
Also, if there was, the use of bots and things, and Drake also probably benefited from that at some point, right?
Yeah, he did. He just didn't benefit from it the way he felt he should have. I'm reading these complaints. He's suggesting that it was unfairly weighted against him, that Kendrick Lamar and the numbers on that Kendrick Lamar track is like 1 billion streams. That's, Taylor Swift territory. I mean, Kendrick Lamar and Drake are two of the biggest names in their specific genre in the world. I mean, these are pop icons now. And this is real money in the music business. We're talking about substantial income, substantial accusations that could affect other artists and how they're dealt with. If it's true that they are committing payola and they're doing it through the digital versions of the $100 bill in the record sleeve, maybe people will be less successful in the future. Maybe we won't have the same numbers.
We may learn more very soon. A hearing is set for December 19th in Texas and January 16th in New York. Fascinating almost cases. Thanks so much, Ron. That's Ron Beanstalk of Scarinci Hollenbeck. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.